case briefs, and so much more. LSData's got what you're looking for.
Swann v. Charlotte-Mecklenburg Board of Education marked a historic ruling by the Supreme Court in 1971, reaffirming that racial segregation in public schools, imposed by the state, violates the 14th Amendment's Equal Protection Clause. The case spotlighted school authorities in Charlotte-Mecklenburg who had been found guilty of perpetuating segregation, contravening previous rulings of law. Prompted by an order from a lower court, these school authorities were tasked with formulating a plan to dismantle the racial division pervading their institutions. Fulfilling this obligation became the focal point of the Supreme Court's verdict. The court upheld this directive, highlighting the necessity of desegregation strategies rooted in fairness and equality. Alongside this was the judicial examination of the treatment of substitute teachers, student teachers, and night school faculties within the context of segregation. Chief Justice Burger, delivering the majority opinion, underlined the intention of this case as an exploration and clarification of the duties of school authorities, as well as the powers of federal courts in purging public school segregation prompted by state action. He recognized the complex and innovatory challenges faced by district courts and courts of appeals, which often had to devise solutions without specific guidelines. In its judgment, the Supreme Court dictated that school authorities must devise a plan to realistically promise desegregation, limited to remedying existing infractions. Tactics of pairing and grouping non-contiguous school zones were sanctioned as potential strategies to accomplish the objective of desegregation. Once desegregation has been substantively accomplished, the court asserted that authorities do not need to make yearly adjustments to the racial composition of the student body, unless compelling evidence reveals deliberate efforts to manipulate demographic patterns. Consequently, the landmark verdict confirmed the previous orders of the district court, emphasizing that racial discrimination in public educational establishments is both unjust and unconstitutional.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class behind.